Ladies and gentlemen, welcome to the Friday Ramblings, where we discuss all things pop culture, including some behind-the-scenes things, which is what we're going to get into today. Instead of simply talking about video games, we're going to do a bit of a throwback to one of my earlier episodes in which I broke down a lawsuit between Universal Studios and Nintendo over Donkey Kong and whether or not it was a derivative work infringing upon the alleged copyright protections Universal Studios had over King Kong. Those of you who watched that video or have researched this case in your own free time know that Universal lost because it was revealed in previous court hearings. It was determined Universal did not own all rights to all things King Kong, and as such, the entire case was a matter of Universal trying to bully Nintendo, as well as some other lesser game companies that released the various versions of Donkey Kong that were coming out, due to it being such an incredible game, into giving Universal money that they did not deserve. Thus, they got legally smacked down. In that case, Nintendo was very much the underdog and the innocent victim. This time, even though I am a huge Nintendo fanboy, I am happy to say we're going to flip that script, because this time Nintendo is starting a legal battle over something that, frankly, they probably didn't need to be starting such a fuss over. And that is Nintendo's lawsuit against Galoob Toys over the game Genie. So, let's get this out of the way real quick. For those of you who are wanting to do your research on your own, the official case is titled as Louis Galoob Toys Incorporated versus Nintendo of America Incorporated, and was decided on May 21st, 1992 in the United States Court of Appeals for the Ninth Circuit. That's information you need to research this case and pull up the court documentation if you would like to read it directly yourself. Now, let's get into the nitty-gritty of what the lawsuit was all about. Louis Galoob Toys Inc., often simply referred to as Galoob Toys, was hired by UK-based Codemasters to manufacture an add-on product for the highly popular Nintendo Entertainment System that Galoob would call the game Genie, due to its existence being a add-on peripheral whose function was, by entering certain codes, wishes, you could temporarily rewrite the game's data, allowing you to alter the way the game was played. Most often, this would result in beneficial codes such as invincibility, infinite lives, unlimited time to complete levels, retaining power-ups after getting hit or dying, which in most games causes you to lose the power-up as a punishment for, dying or getting hit. Although there were occasionally negative game Genie codes, such as instead of, say, having 3 lives to play a game, you only had 1. Or in a game where, hey, you've got an energy meter and you can take 4 or 5 hits before dying, such as the Legend of Zelda games, for example, you could use Game Genie to hack it so that it now played as a one-hit kill game, which would obviously greatly increase the difficulty. Now, in and of itself, it doesn't sound necessarily that bad. It allows the players to have a customized experience to their gameplay. And in modern times, well, it's not really a big deal, You can go over the internet and find cheat utilities and hacks and randomizers and remixers, and it's not that unheard of to have products that alter the way the game's played for your own personal enjoyment. Here is a little bit of the wrinkle, though. First of all, most of those products you find on the internet are freeware. They are not commercial products that the person pays money to own. You know, a lot of them, if they're part of ongoing development, instead of a quick, dirty one and done, you know, will allow optional donations so you can support the programmers and encourage them to come out with other utilities, but they are not officially commercial products, whereas the Game Genie was. And as such, the Game Genie was sold in stores, and Galoob Toys, being a major manufacturer, meant that it was in a lot of stores, and it had advertising campaigns. This caused Nintendo to object, as they felt like giving consumers control over how the game is played philosophically undermined their work in creating the game, as it became a case, as, you know, from Nintendo's perspective, you're basically encouraging people to change the product and make it something it's not, as well as, you know, frankly put, takes away the challenge of a lot of games. And in the video gaming community, you know, beating a really challenging game is a mark of honor. It's a mark of pride. Now, of course, in the modern video game community, hey, if you cheat and you don't admit you cheated, you know, you're called out and made a mockery of, and you get no respects. Many people, especially in the speedrun community, have been ostracized and shunned and kicked out of the community for cheating and faking speedruns. But that's a little bit of a different subject. However, legally, Nintendo couldn't sue over that. So what they did was sue under the idea that it is creating derivative works. That they get by the Game Genie altering the data of the game and changing the way the game was played, it created an entirely new game on a legal intellectual property level. Thus, it was a game that was derivative. It was a new game violating copyrights by being too similar to somebody else's previously existing game, which is illegal. You know, if I take, we'll pick on a relatively recent game a lot of people have heard of, Super Mario Odyssey, and I change the color of the clothing of a lot of characters, and I change it to where certain goals give you extra rewards, and I change the M on the cap to a U, and I call it, you know, Ultra Crazy Odyssey, and I, you know, Nintendo can shut me down because it's clear that I'm just taking their game and I'm putting a tiny bit of nonsense on it and trying to claim I created a whole new product. That was the crux of Nintendo's lawsuit. That is what a derivative work is. That is illegal if Louis Galoob Toys Inc. actually did that. Louis Galoob Toys' defense was that because the data altering is of a short-term basis, as in as soon as you turn the game off, the data altering is ended and you have to re-enter the codes all over again. And as such, you can't exactly change the data, turn around and sell the game as your own thing to other players. It's not a derivative work. It's not cheating commerce because Galoob's not making profit from permanently altered games. Individual consumers aren't because, as I said, the data altering is a temporary basis. hence why you have to have the add-on peripheral connected onto the game every time you play. And you have to re-enter the codes every time. It's short-term hacking, not permanent hacking. That was Louis Galoob's Toys Inc.'s defense. You know what? It's a lot to say. We're going to go back to the informal and refer to them simply as Galoob from here on out. But Nintendo persisted with this, especially when the early and highly successful sales of the game Genie NES peripheral was inspiring Galoob to push out Game Genies for other products, including Nintendo's own Game Boy, as well as competing like Sega Genesis. So, what happened? Well, the court battle began in May of 1990. As I said, it was not finalized until 1992, so this was a long battle. Galoob initially files the complaint against Nintendo in U.S. District Court, seeking a declaratory judgment that the game Genie did not violate Nintendo's copyrights, as well as an injunction preventing Nintendo from modifying their NES game system to make it incompatible with the game Genie. Nintendo responds by filing the complaint against Galoob, seeking an injunction preventing Galoob from selling the game Genie. Now, a similar court case, Midway Manufacturing versus Arctic International, had previously been decided in favor of the copyright holder, and Nintendo relied heavily on this case as precedent for its legal arguments. Real quick, for those of you who are not really keyed up on your legal matters, Precedent is a system wherein the courts look at a civil hearing and say, okay, look, this is exactly the same as this case that was ruled on previously. We said this is what the law hinges on, so we don't really have to have a full trial over this. We already know the answer because we've already said the answer for these other people. That's a precedent. You say, we've done this already with different companies. Legally, we know what's going on. It's the exact same situation. There's just some proper nouns that have changed. So, bam, boom, quick judgment. And that's a wonderful thing in legal matters because it allows a lot of cases to be run through the courts very quickly. So the really complicated cases, there are highly competent judges who have the free time to hear them. In theory, that's the way the system works, and that's why precedent's important. So Nintendo was relying on a ruling of, hey, this is a precedent, this has already happened, declare us the winners. Now, Nintendo was originally granted a preliminary injunction preventing Galoob from selling the game Genie until the court matter was resolved. However, it also ordered Nintendo to post a bond in order to ensure Galoob be compensated for sales lost during the injunction should Galoob win the case. The bond was initially set at $100,000, however, due to the fact that the case took 2 years to resolve, it was later increased to $15 million. Galoob initially appealed the injunction to the Ninth Circuit Court of Appeals and lost. The initial trial was concluded in July 1991 with District Judge Fern M. Smith ruling in favor of Galoob, declaring that the game Genie did not violate Nintendo's copyrights. In her ruling, Smith compared usage of the game Genie to, quote, skipping portions of a book or fast-forwarding through a purchased movie. Thus, the altered game content did not constitute the creation of a derivative work as Nintendo had argued, which is what I foreshadowed earlier by pointing out that the temporary nature of it did not fundamentally alter the actual product purchased and thus prevented reselling of an altered product under claims of it being a different work. That's the key to the whole trial, the permanence of the alterations. So, Smith wrote that having paid Nintendo a fair return, the consumer may experiment with the product and create new variants to play for personal enjoyment without creating a derivative work, as the concluding of the judgment. Nintendo appealed the verdict to the Ninth Circuit Court of Appeals, but did lose as the Ninth Circuit affirmed the lower court's decision. This means that a later hearing was held to determine how much the $15 million bond would be awarded to Galoob to compensate for losses during the approximately 1-year period that prevented them from selling the game Genie. The court found, though, that because Galoob's losses actually exceeded $15 million, Galoob was entitled to the entire amount plus legal fees. Nintendo tried to appeal this decision to the Ninth Circuit, but lost once again, so Nintendo was out a lot of money. But lesson learned. Nintendo forgot the simple rule that just because you've won a few ones as the underdog early on doesn't mean you'll always win. So, what's the long-term legacy of this? Well, as I pointed out, various Game Genie peripherals were made for multiple consoles over the years, and the fact that a device designed to create temporary rewriting of data for video games allowed later's existing things such as the game Shark, which has been used in more modern consoles, as well as the Action Replay, which is another good one that was put out on multiple consoles, to even exist at all. Trust me, if Galoob had lost that and the Game Genie had been shut down that early on, nobody else would have made their own variations of it. But on the legal side, well, the Ninth Circuit referred to the Galoob ruling in MicroStar vs. 4Gem Inc., a case involving user-created levels for the video game Duke Nukem 3D. In that case, Judge Alex Kaczynski concluded that the fair use analysis in Galoob vs. Nintendo is dicta, which means that it is an authoritative or dogmatic statement, and as such, basically it's very into the idea of precedent. It's like, look, this is how it's going to apply. That's it. There's no discussing this. And thus ruled in favor of the copyright holder. 2002 case involving the Clear Play technology raised a similar issue in the context of home viewing of DVDs. At no point was a copy of the DVD made, rather offensive parts of the movie were automatically skipped. Hollywood Studios and the Directors Guild of America sued Clear Play, alleging copyright infringement and trademark infringement. The case, however, was rendered irrelevant by the passage of the Family Entertainment and Copyright Act of 2005, a law that, because of its narrow applicability, did not abrogate Midway or affirm Galoob. This means there was no judicial opinion issued in the case involving Clear Play because it became moot in light of the new law. So, what does this mean? Well, for video gamers, as I said, it has meant that for the last few decades, commercial, short-term cheat devices have been legal for industries to create and sell, as well as reaffirming that freeware cheat utilities can exist and be put out on the internet without a easy peasy slapdown from the creators of the game, because, hey, courts ruled Galoob could do it for a commercial product. Why can't we do it for a non-commercial product? It's even less fear of copyright infringement because we're not making any money off this. We're just doing this for the fun of it. We're just doing this to show off our programming skills. For legal terms, as I said, the case has been referenced in similar cases in not only the video game industry, but in the home entertainment industry in general. Although it would have been interesting to see how the Clear Play case would have gone had the laws surrounding such issues changed. By the way, real quick, since we do have a few more minutes, we're going to go ahead and discuss the Family Entertainment and Copyright Act of 2005, which is a It is a federal legislative act regarding copyright that became law in the United States in 2005. The act consists of two subparts, the Artists' Rights and Thief Prevention Act 2005, which increases penalties for copyright infringement, and the Family Home Movie Act of 2005, which permits the development of technology to sanitize potentially offensive DVD and video-on-demand content. That second part would be what affected the Clear Play lawsuit. The act provides theater owners and employees with both civil and criminal immunity for questioning suspected violators or detaining them while police are summoned. And this basically allows for people to, as the consumer, have a say in how they choose to expose themselves to certain kinds of art. Now, personally, I have my own feelings on such an act. I'm of the opinion that, if you don't like portions of a movie, such as the dialogue, whether it be profanity or spiritually awkward context, don't watch the movie at all. Now, on the flip side of that, I do believe this is why rating systems do need to be very direct and detailed in providing information to the consumer about why movies have particular ratings. It's not enough to simply say, hey, we really don't think children should watch this. You should be saying, hey, we really don't think children should watch this because there's profanity and sexual content in this movie, so that people can make informed, intelligent decisions about what they choose to be exposed to. But what can I say? I am an artist. I am a creator. Flipping back to the original content of what we're talking about, hey, I have nothing against the game Genie. I have nothing against cheat codes. On this same channel, I have a streaming series there where I play video games. And on a handful of occasions, I have used cheat codes so that I can take particularly hard games that I enjoy playing, even though I'm not very good at them, and still allow me to show the viewer the entire game to hopefully spark their interest in checking the game out as well. Now, of course, when I do that, I am very explicit in pointing out that I am cheating and using these codes to make it clear that this will not be the typical experience and that this playthrough is not about showing off my skill, but showing off the game itself. So, more power to the player and plenty of upfront information. Because when you're talking legality, that's the best thing you can do. Be as upfront and honest as possible about the situation. So, for Nintendo, they lost a lot of money there. Over $15 million all at once. Good news was, this is the early 90s. The NES was hitting hard. Super NES was right there, along with the Game Boy. They had 3 strong systems, along with an impressive library of games. The company was able to make up the losses without any kind of bankruptcy, which unfortunately can't happen in a lot of these lawsuits. As we mentioned when I discussed the earlier Universal versus Nintendo, because Nintendo at the time didn't even have one home console, as they were still working on development of the NES when Universal sued them over the arcade cabinet version of Donkey Kong. Nintendo of America could have gone out of business, most likely would have, if they had lost the lawsuit to Universal. So, sometimes you win, sometimes you lose. Sometimes the law is your friend, sometimes it is your enemy. The key, as I said before, be as honest and upfront as possible about what you're doing. Play nice. Be respectful. In fact, that last one is one of the classic rules in which we run roulette productions. We'll criticize. We'll talk about personal opinions, but we do not pick fights and we do not grind axes. That's why there's certain movies, TV shows, video games, whatnot, I do not talk about. Because, hey, there's enough negativity and there's enough legality on the internet. If you're interested in much more in-depth legal analysis from professionals, there are a handful of really excellent legal channels on YouTube. I'm not going to give them a direct call out right now because, frankly put, I don't want anybody thinking I'm, trying to buddy up with any channels, try to leech off their fan base, suck up the creators that might have bigger subscriber bases. I'm not into that. We're going to have natural, organic, honest growth here, folks. But the channels are out there. If you want, talk to me on my Twitter. It'll be down in the description. We'll make it rock. We'll take care of business. We'll discuss things in private if you want those recommendations of some of my personal favorites. But, that's that. That's it for this week. Hope you enjoyed this look at what happens when lawsuits get down and dirty and how data altering has had quite a deep history in video games and almost got shut down at the forefront of it. But most importantly, highlighting the fact that while I am a huge fan of Nintendo, I'm willing to admit when they step over the line and when they try to be a little bit petty. So, sorry Nintendo, I love you, but when it comes to Galoob, you should have just let them have their own toy. Because, honestly, it's not like it hurts y'all's money. Except in the short term when you had to cut that check. Whew! I don't even want to think about having to tell my boss, sorry, we kind of lost y'all $15 million and some change. Whoopsie. See you next week. Like, comment, subscribe. Tell your friends. Tell your enemies. But the roulette spins on and the entertainment keeps coming. Later, taters.